I rise to speak on this important piece of legislation. This parliament, every day, as we did today and every other day, we open with an acknowledgement to the traditional owners of the land on which we stand. In the halls of Parliament House, we appreciate the stunning Indigenous art from over the country. We have a former Prime Minister who apologised for the stolen generations in this very building. And I want to begin my speech today to take the opportunity, as I have many times before, to acknowledge the traditional owners of the land, the Ngunnawal and the Ngambri people, to acknowledge their elders past and present, and to note that sovereignty over this land was never ceded. Let's think about that last sentence. This land was never ceded. It was not ceded, it was taken. To try and make some reparations for taking this land, this parliament passed the Native Title Act in 1993, and native title has been an important step along the way towards land rights. And for such an important act, one would think that any changes would be considered extremely closely and to follow proper process, scrutiny, consultation and engagement. But what we are debating today really seems to just fly in the face of that. In fact, it's basically saying, why bother with all that scrutiny at all? Here we are in this parliament about to vote on changes to this important act, despite the fact that there has not been enough consideration of the implications of these amendments and the consultation with Aboriginal people, which has been anything but full and thorough. The Greens opposed this bill in the House of Representatives. This bill was introduced and rushed through the House of Reps pretty soon after the federal court decision because of the threat to the Adani mine if the Indigenous land use agreement that covered that mine was found to be invalid. The timing of this bill is about that Adani mine, not about proper consideration of native title. We know that Indigenous owners have made many representations and concerns about the native title legislation, about the decisions made under the Bygraves court decision for some time, and had raised them with the government. And we know that despite that we've got legislation that's being rushed through, with an incredibly short time for our Senate inquiry, which was totally inadequate to hear the concerns and to thoroughly debate and understand what the consequences of this legislation are going to be. We as Greens have had concerns about the time frame from the very beginning, and we attempted to extend the reporting date for the inquiry, but unfortunately this was not supported by the Senate. And so consequently, submitters did not have enough time to compile their submissions, and the committee was only able to hear one hearing for such a substantial change to our native title legislation. This is of huge concern given the complexity of native title arrangements and the significance of these amendments. A core concern that we've had with this bill and the process has been the lack of adequate consultation that's been undertaken with Aboriginal and Torres Strait Islander communities regarding this bill. The Greens accept there is a need to address the issues raised by the McGlade decision, but we cannot support this bill until there has been that proper consultation with the Aboriginal and Torres Strait Islander peoples, communities, organisations, and really thorough consideration of all the consequences of proposed legislation. So, given that hasn't occurred, I reiterate, why are we here today? Why are we about to vote on this legislation? It's got nothing to do with native title. We are here today to help the Labor and the Liberal mates of the Adani coal mine and their dirty, polluting, reef-cooking, climate-destroying coal mine. That's why we are here today, to be trying to be supporting something that goes completely against the interests of Indigenous peoples across this country, of all the peoples of this country, of all the peoples of the world, given the consequences of this coal mine and the carbon pollution that will entail if this coal is mined. Acknowledging the traditional owners in this parliament is hollow when you support changing the Native Title Act to favour your mates in a coal mining company over the rights and the interests of traditional owners. And it is despicable the way that traditional owners are being used as pawns in this debate, and how the members of the Wangan and Jagalingou people who dare to disagree with the ILIA that has been made over their land, the destruction of their land by a massive coal mine, have been vilified. These traditional owners have been speaking out over the last week, and probably the most well-informed person in the country about the legal issues involved and the interaction with Indigenous rights is Tony McAvoy, who is a senior counsel and the first Indigenous silk in the country, and he is a Wangan and Jagalingou traditional owner. And he was reported on the weekend strongly rejecting the claim that Marsha Langton had made that Indigenous people had become collateral damage as the so-called environment industry hijacked the Adani issue. McAvoy said to suggest that the Greens are puppet masters pulling the strings and we're somehow puppets was wildly off the mark and disrespectful to the many families opposing the mine, including his. His and the other W&J traditional owners' view is that there is no need to rush to pass law changes dealing with critical issues around Indigenous property rights through future land access deals. The other information that's come out since we were last debating this in the chamber last month has been what a sham of a process the supposed approval that was given for the ILIA for the Adani mine. Spokesperson for the W&J Traditional Owners Council, Murray Johnston, giving a keynote address at the National Native Title Conference last week, said that Adani's approach seems to be fake it until you make it, but the reality is they can't and won't proceed in the face of our resistance. And the W&J traditional owners have said that they will bring forward evidence to the federal court hearing that is now to be heard in March next year on the Adani ILIA to demonstrate that Adani did not negotiate and achieve the free, prior informed consent of the W&J people. And Murray Johnson says that the meeting, which Adani and its barrackers claim achieved consent with a 294-to-1 vote, is not a true expression of the W&J traditional owners. With over 220 of the attendees at the Adani meeting were people who had never been involved in the W&J claim or decision-making and who are identified with other nations and claims or don't identify an apical descent line, that many of the people were bussed in and paid for at Adani's considerable expense, and the majority of the claim group, which have 3 times rejected an ILIA with Adani, refused to participate in this stitch-up of a meeting. Many members of the claim group stayed away. But at least with this Adani mine, they have got a federal court case to be heard in March next year. But what of the other ILIAs that stand to be retrospectively agreed to, where it's clear that there is considerable controversy over them? Like Cape York agreements that were made despite the fact that all of the native title claimants were deceased. Clearly, after the McGlade decision, there is a need for change. Clearly, the situation at the moment as to which native title claims, the ILIAs, who needs to be involved in the agreement of an ILIA, there needs to be changes made. Tony McAvoy, I think we need to listen to in the way forward that he's proposing. And what he has identified is the problem with the approach being proposed in this bill, with having a majority approach, is that in many native title claims, the claim groups have needed to ensure that each family group or clan is represented within the applicant or registered claimant to protect the differential interests of that family or clan. And this is particularly so where one large family or clan can outnumber the other groups, as is often the case. And on the bill as it's presently drafted, that large family or clan or group of families or clans could win a majority vote at a meeting to approve a mine, for instance, over the land or waters of another clan or over sites for which another family has special rights and responsibilities. This is not a fair, considered, appropriate and just outcome to achieve. So what Tony McAvoy asks for and what the Greens are asking for is that to amend the Native Title Act, we need to have a detailed and a nuanced approach that is protecting rather than undermining the property rights of the various clans and families that make up each native title claim area. McAvoy notes that it must be done with care, as the failure to get it right will permit the property rights and the interests of particular families and clans to be extinguished or impaired without their consent. Tony McAvoy, says that I encourage the members of federal parliament to take a deep breath and come to terms with the fact that the property rights of Aboriginal and Torres Strait Islander people all over Australia will be affected by the proposed amendment to Section 24C and D of the Native Title Act. This amendment should not be rushed in order to appease some other agenda. Surely that is good advice that we would be wise to take. Clearly, action is required. Clearly, amendments are required. But we owe it to ourselves, we owe it to the Indigenous landowners and native title claimants across the country to be making these changes properly, taking time, doing it properly. The Greens are committed to working for sovereignty and treaty with Indigenous Australians, and we know that we will never be at peace with ourselves as a nation until we have achieved treaty or treaties that recognise the prior occupation and sovereignty of Aboriginal and Torres Strait Islander peoples. This bill goes against all of that. So let's repeat the real reason why we're here today. The real reason why we're here today is not about good governance. It's not about getting things right. It's not about making sure that we have a fair and just process for native title into the future. We are here today to help the Liberal and Labor mates at Adani and their climate disaster mine, and in doing that we will be trashing the rights of traditional owners whose land was never ceded.